Count 2, assault of a child by a person who works or volunteers with children.
According to her, she asked him out when she was 17 years and 9 months old. According to her, they had sexual intercourse 3 times.
And you knew that she had 1 month until she was 18.
Welcome to Bench Report Court Cam.
All right, I have an MR. I'll ask, who is MR? Oh, now the MR is gone. Who is the Samsung? Still trying to connect audio. Who is the Samsung that just came into the courtroom? If it's a victim, you can just tell me your initials. The Samsung, I'm asking you to unmute.
Nicole Nelson.
All right. We will go on the record in the matters 24 CF 105, 24 CF 112, State of Wisconsin versus Noah Gosman. The state appears through District Attorney Kevin Schmidt in person. Mr. Gosman appears in person with counsel Nicholas Davis. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. We are in victims' rights compliance, correct?
Yes.
Mr. Schmidt, excuse me, Mr. Davis, can you please recite the agreement for the record?
Your Honor, I would, if you'd allow me, I'd have the district attorney put the agreement on the record, please.
Yes, Mr. Schmidt.
Mr. Gosman is going to be entering a plea to 3 counts. The counts are going to be 1 count of the H felony, person who volunteers or works with children, has sexual intercourse with them, and then 2 counts of the misdemeanor, person over the age of 19 has sexual intercourse with person 16 or older.
And 2 misdemeanor counts, you said?
Yep, they're all in the complaint.
All right, and so it'd be like count 5 and count 5 and then count 10?
Yep, the idea is you can probably guess is 1 for each instance of sexual intercourse. The agreement is 2 years probation on the misdemeanor, 5-year DJOC on the felony. The felony requires a sex offender evaluation and follow through. No contact with minors unless they're related by a blood or family.
Okay, all right, basis for the agreement that's reached and why it's in the public interest?
Yeah, Judge, a lot of counts are being dismissed because the police investigated 3 crimes and referred charges for 3 crimes. This person who works or volunteer with children having sexual intercourse, the evidence of what the police investigated is strong. The victim and the defendant admitted they had 3 instances of sexual intercourse. They described when it happened. The victim was tracking it on some sort of app on her phone, so we had specific dates. It occurred at the driving parking lot of the subway in Siren. When they sent it up, the former district attorney added a whole bunch of other charges without consulting with police. Many of the charges lacked probable cause. The child enticement counts lacked probable cause because in all 3 instances of the sexual intercourse, they did not relocate once it was initiated, and it was an extremely public location rather than a secluded one. The contributing delinquency of a minor counts alleged that the victim NJ committed the crime of exposing herself to the victim Noah Gosman, which made no sense. The misdemeanor sex assaults, 2 of which he's pleading to, are actually lesser included of the felonies under the Blockberger test. I confirmed that with DOJ before reaching that conclusion. So that's why we're kind of mixing and matching that there. The exposing to a child, I guess technically works. I think you can charge that in any case where someone has sexual intercourse with them. It just kind of misses the mark of what the case is about.
Okay, all right. And so that's the agreement that you've reached, Mr. Gosman?
Yes, it is.
And you fully understand the agreement that you've reached?
I do.
All right. So we do have 2 people, 2 victims who are going to be making statements here today. I'm going to take the statements first. I do have one by video. Oh, she's not. Yeah, she's here. Yes. And I think she said NN. You can please state your name and give me a statement, please.
Do not wish to make a statement.
All right, so no statement. All right. So Ms. Bauer, the other individual, please. And when you get to the table, you can either state your name for the record or your initials, whatever you prefer. All right, you may have a seat. And then please let me know how you are related to the case and what it is that you would like the court to know.
I am the stepfather. What I would like to address the court is the impact that this has made. It started as a 16-year-old daughter who had dreams becoming a registered nurse. She was enrolled in the Pine Tech. She was going to do as much as she could schooling there, then go over to Ramsey and finish out her RN. Since this has all started, she can't show, she doesn't feel comfortable showing her face. She has dropped out of school. She got as far as a CNA and she moved away from Grantsburg, found friends that would take her in, made new friends and not good friends by all means. But, 18, there's nothing you can do at this point. Has spiraled downhill. Has a hard time holding a job. Most likely probably be getting her car taken shortly. Can't make payments on anything. And she was a very good person, a very, very, well, she was a nice child. She was, never had issues with school, and when she did have issues, she got help and she overcome it. She always wanted to follow in her mom's footsteps as an RN. That was her goal. It was to help elderly people, be in that scenario. And since then, she don't even go out in public. She don't want anything to do with people in general. Just like I said, she just spiraled. This whole thing has impacted me and my wife. We've had issues on how we should handle things. You've seen her here more than you've seen me because I don't handle things very well. I can get very irritated fast. The manner of which of this is, I try to stay away and distance myself as much as possible. Otherwise, I'd be in court here too. That really wasn't how I wanted to play this out. Where we were from the very beginning to where we are here, this is what you guys do. Do I feel it's just as a father, as a stepfather, as a husband? No, I do not. Do I think there should be some jail time involved? Probably. This guy used his bus driver to get close to a child at 16 years old started. He used his cop as a Wisconsin police officer at one point to manipulate this child all the way up until she was 17 and 10 months, 11 months, whatever it was. So, I mean, it just hasn't been going on for just a short period of time. There was a point in time where me and Nicole stepped in when she was 16 and told this gentleman to stay the F away from our kid. So he knew he was doing something wrong. He held a badge to uphold people from doing something wrong like this. And I think he's getting off pretty easy. I don't know what else to say. I really don't.
All right, I appreciate that. Thank you, Mr. Nelson. You may go have a seat. All right, before we begin, I did look at the plea questionnaire waiver of rights form. It is not signed by Mr. Gosman. And while I'm waiting for the signature, NN, are you sure that you do not want to make a statement?
Okay.
I'm sure. I think Mike was very clear that this was occurring way before. and did a pretty good job.
All right, thank you. Thank you, Mr. Davis. So I have in front of me a plea questionnaire waiver of rights form along with the deferred judgment of conviction document. Mr. Gosman, do you recognize these documents?
That's what I
Yes.
signed. Yes.
Did your attorney thoroughly go over these documents with you?
Yes, he did.
That is, did he essentially read them word for word?
Yes,
And you understand everything on these documents?
I do.
If by chance you didn't understand something, did you ask your attorney to explain it?
Yes,
And he did so until you understood it.
yes,
And on the second page of the plea questionnaire and the third page of the plea, or excuse me, of the deferred judgment of conviction document, are those your signatures?
yes, they are.
So you're telling the court that you went over these documents and you fully understand everything.
Yes,
You are pleading guilty to two misdemeanor counts in the 24 CF 105 of having sexual intercourse with a child 16 or older, actor 19 or older, 19 or older, excuse me. Okay, I'll repeat that. So you're pleading guilty to two counts of misdemeanors of sexual intercourse with a child 16 or older, where the actor is at least 19 or older. Is that correct?
yes,
And you're pleading guilty to one felony count, and that would be to the sexual assault of a child by a person who works or volunteers with children, an H felony. Is that correct?
yes, it is.
You're 32 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that correct?
That's correct.
And your attorney thoroughly went over with you those charges that you're pleading guilty to, as well as what the state would need to prove your guilt beyond a reasonable doubt?
Yes, he did.
And did your attorney go over with you the maximum possible penalties you face?
Yes,
You are not receiving any treatment for mental illness or disorder, no drugs, alcohol, or other medications, correct?
that's correct.
I do not know why my voice is getting harsh or hoarse. Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on the document. Do you understand those rights?
Yes, I do.
Did your attorney thoroughly go over those rights with you?
Yes, he did.
And you understand them completely?
I do.
Do you need me to go over those rights with you in any more detail?
No.
You understand them completely?
Yes, I do.
And those are the rights on the first page of the plea questionnaire, as well as the deferred judgment of conviction document. Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes,
Do you understand that as to that felony count, count 2, sexual assault of a child by a person who works or volunteers with children, the state would have to prove on or around April 11th, 2024, in Burnett County, Wisconsin, you had sexual intercourse with a juvenile, victim 1, date of birth, May 26, 2006. A child who has not attained the age of 16 and is not your spouse, and with whom you work with or interact with through your occupation or a volunteer position. Do you understand what the state would have to prove?
ma'am,
You may ask your attorney a question.
and it's supposed to be 18, correct?
Your Honor, what you conveyed to me is he believes that the child had reached the age of 16. When this occurred, she was,
Mr. Schmidt?
What's the question?
The count says a child who had a, she had. I will repeat that.
Yes.
What the state needs to prove is on or around April 11th, 2024, you had intercourse with a juvenile victim, 1, date of birth, May 26, 2006, a child who had attained the age of 18 and is not your spouse, and with whom you worked with or interacted with through your occupation or volunteer position. Do you understand what the state would have to prove?
I think the confusion the court keeps saying is had attained the age of 18. It's has not.
Is it has not or had?
It has not.
Has not, yes.
I am reading exactly what you charged.
That needs to be changed then.
Count 2, a child who had attained the age of 16.
Yes.
I read
Yes.
it exactly from,
I concur with that. You're right. That's, yeah, she had attained the age of
so
16.
so she is over the age of 18. She's 16 or older. Is this the charge that he's pleading to or not?
Should be count 2.
That's what I read.
The court, because the criminal complaint says 16. What are you reading?
I'm reading the criminal complaint that says a child who had attained the age of 16.
Yes. You were saying 18 in the colloquy. That's been the confusion.
All right, did I say 18? All right, I apologize. Again, count 2, sexual assault of a child by a person who works or volunteers with children. The state would have to prove on or around April 11th, 2024, in Burnett County, Wisconsin, you had sexual intercourse with a juvenile victim, one whose date of birth is May 26, 2006, a child who had attained the age of 16 and is not your spouse and whom you worked with or interacted with through your occupation or a volunteer position. Do you understand what the state would have to prove?
Yes, I do.
Do you understand that the maximum possible penalty of this H felony could be a fine of up to $10,000 or imprisonment up to 6 years or both? Do you understand that?
Yes, I do.
All right. I am looking at my notes and I said 16, but all right. So you understand what the state would have to prove and those maximum possible penalties.
I do.
Count 5, sexual intercourse with a child. The state would have to prove on or around April 11th, 2024, in Burnett County, Wisconsin, you did have sexual intercourse with a child, juvenile victim 1, date of birth May 26, 2006, who was not your spouse and who had attained the age of 16 years, and the actor, you, had attained the age of 19 years or older. Do you understand what the state would need to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of not more than 9 months or both?
Yes.
And you understand, so you understand what the state would have to prove and that maximum possible penalty.
I do.
And with regards to count 10, which is essentially the same charge, but a different date, it alleges, and the state would have to prove on or around April 18th, 2024, in Burnett County, Wisconsin, you had sexual intercourse with a child, juvenile victim 1, date of birth May 26, 2006, who was not your spouse and who had attained the age of 16 years, and you had attained the age of 19 years or older. Do you understand what the state would have to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
I do.
Do you also understand that there is an agreement reached by the parties here, a joint resolution, whereas you would plead guilty to these 2 counts of misdemeanors, and that you would plead guilty to that H felony, and with the misdemeanors, the court will put you on probation, and with the deferred judgment of conviction, that would kind of hang out there for a period, I believe it was for 2 years,
Yes.
60 months, for 60 months. So for 5 years, it will hang out there, and if you violate those conditions, then this agreement will be revoked and you will be in front of the court for sentencing on that felony charge. Do you understand that?
Yes, I do.
Do you understand that this is the agreement of the parties and I'm not bound by that?
Do you understand that?
That in reviewing the facts of this case and your history and your characteristics and the need to protect the community, if I think that a different sentence should be rendered in this matter, do you understand that I can do that even if it's to the maximum possible penalty.
I understand.
Do you still wish to proceed and enter guilty pleas here today?
Yes, I do.
Did you go over the criminal complaint with your attorney? And that is that document that basically says what happened those days and why you were charged with these crimes?
Yes,
For the most part, are those facts accurate?
for the most part, yes.
So you're admitting here today that you did have sexual intercourse with a juvenile who had attained the age of 16.
We stipulate that happened. The defense stipulates to that.
All right. Mr. Davis, did you thoroughly go over the facts alleged in the criminal complaint with Mr. Gosman?
Yes, we've gone through this quite a bit, a lot actually. So he's aware of everything.
Understands those facts that are alleged
He does, Your Honor.
and what the state would need to prove in relation to the facts?
We actually went through the jury instructions themselves, so he understands, Your Honor.
All right, thank you. May the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, the defense stipulates.
Has anyone made any threats or promises for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Ma'am?
And voluntarily?
Yes,
Are you pleading guilty to these charges because you are guilty?
yes,
Did your attorney represent you competently?
yes,
Has he answered all of your questions?
yes.
Has he looked at this matter thoroughly?
I believe so.
Has he went over with you the potential defenses you could have or a lack of defenses you could have?
Yes, he did.
Did he discuss with you the evidence in this case attained through discovery and what the state would need to prove your guilt beyond a reasonable doubt?
Yes,
And so, are you satisfied with your attorney's services?
I am.
Do you have any questions for this court or your attorney before I proceed?
No, I do not.
As to that felony count, a deferred judgment of conviction is being offered to you. If the court accepts it, do you understand that you wouldn't be under this felony restriction, but if the court does revoke it later and you're sentenced, you would be, and that means you would no longer be able to use or possess a firearm for life.
I understand.
You would no longer be able to vote in any election until your civil rights are restored.
Yep.
And you understand that thoroughly.
I do.
Now,
He also understands that because the nature of the offense, that he would never be able to work or volunteer with children, anything like that. I went through that with him too, Your Honor.
all right, because has there been a discussion on the sex offender registry?
Yes, I believe at this time I believe the state's not making such request.
All right. Do you understand what it means to have a dismissed but read in charge?
I do.
And do you understand that with all of those counts that are being dismissed and read in, I could still look at them with regards to sentencing,
Yes,
but I cannot go beyond the maximum possible penalty for each of the charges? Do you understand that?
yes, I do.
Do you wish to proceed and enter a guilty plea?
Yes,
And Mr. Davis, you thoroughly went over everything, the strengths and the weaknesses of the case with your client?
Your Honor, we met in my office multiple times on that. We certainly did.
And do you believe that he is entering his plea here today competently?
I believe he is, yes.
And do you believe he understands that he is giving up his constitutional rights here today and what that means?
He does understand that, Judge.
And do you believe his pleas done today have been done freely, intelligently, and voluntarily?
I have put no pressure on him. No one has put any pressure on him. He is doing this on his own free will. Thank you.
All right, thank you. Then, Mr. Gosman, as to count 2, sexual assault of a child by a person who works with or volunteers with children, a class H felony, how do you wish to plead?
guilty.
As to count 5, sexual intercourse with a child 16 or older, actor 19 or older, an A misdemeanor, how do you wish to plead?
Guilty.
As to count 10, sexual intercourse with a child 16 or older, actor 19 or older, an A misdemeanor, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of all 3 counts. As to Count 2, the court will hold that with a deferred judgment and hear arguments on that, at least at this time. With regards to the other 2 counts, a judgment of conviction will be entered today. Argument and the other matter is dismissed and read in as well. Other matter, I said that, argument and sentencing recommendation, Mr. Schmidt.
Thank you. As I articulated for the public interest, this complaint should have been 3 charges at the start. The 3 charges should have been that person who volunteers have sexual intercourse. This is an optimal resolution for this case for a number of reasons. One, the nature of these convictions and this adjudication of guilt in this DJOC will have a large effect on Mr. Gossman, not just because he doesn't have a criminal history, but because given what his past work has been and what his goals for future work, it's going to have a severe effect on choosing his future employment and those sorts of things. The very nature of this, the connection to the NCIC with the arrests when anyone runs a background check, is going to make sure that he's not going to be in a position where he could potentially engage in the sort of behavior that I think you heard the stepfather talk about today. What we're doing here today, why aren't we arguing for any incarceration? I don't think it likely Mr. Gaussman's going to reoffend based on his age, based upon his lack of criminal history, and just given the specifics of this case. This is a case where at one point in the past 2 or 3 years, well, 2 or 3 years before 2024, Mr. Gaussman was a bus driver for the victim in this case. She came to know him and consider herself her friend of his for about 2 years before that. According to her, she asked him out when she was 17 years and 9 months old. According to her, they had sexual intercourse 3 times, as described in the complaint, when she was 17 years and 11 months old. Mr. Gaussman, because of his history and his past employment, obviously knows it's 18 in Wisconsin. If he had waited a month, there'd actually have been no crime at all in this case, and he didn't. This was a case where the victim was very clear it was consensual. I think by the time she even talked with law enforcement for the interview, she might have already been 18. Right now, she's 19 years old. She is not a girl anymore. She's an adult woman. Back then, she was very close to being an adult woman. And even in the interview, she shows a level of maturity that kind of makes us different from the types of cases where we're talking about young, like 13, 14-year-olds, that kind of age range, where you're imagining the very difference in like the psychological development. This was a person who was much closer to the adult end. And in fact, when the police were interviewing with her, they had to be clear she wasn't in trouble. She thought she was being attacked because she didn't even comprehend that any of this was wrong. She was talking about like marriage and moving in with Mr. Gaussman. And it was a very different view of this case than I think what the law recognizes in Wisconsin. So I think given the age of that victim and the past history and this new conviction being the only convictions he has, I think this is the best way to make sure if there are any sex offender things with both the requirement in the DJOC and the probation, it's going to be dealt with. I think if he does reoffend in the next 5 years, it gives a huge hammer for the court to deal with that then. I think right now we're looking at him as a person who really made an extremely poor judgment call with someone who is, despite being close to 18, a large enough age gap where there should have been recognition that that difference in life experience can be very significant in understanding and control and things like that in relationships, specifically when you get down to those teenage years. It's very different than, say, like a 10-year age gap with someone who's like 50 and 60. So I think this recognizes the morality of that while also appreciating what laws were broken. Thank you.
Thank you. Before I get to you, Mr. Davis, I want to make sure, Mr. Schmidt, that I heard you correctly. You indicated that he's pleading guilty to these 3 charges, and these 3 charges should have been the only charges initially charged. Is that what you stated?
Yep, the child enticement counts and the contributing delinquency of minor, those don't even have probable cause. So I think those would have been dismissed before the defense even started at trial. I wouldn't even have gone to trial on those.
And for record, you weren't the district attorney who filed this. I just want to make sure that that's clear. You are now the district attorney and you have reviewed this, and in your review, that's your conclusion.
Correct, and these 3 counts are the 3 counts law enforcement recommended to begin with, no others.
All right, thank you. Mr. Davis.
Thank you, Your Honor. So I think that any conviction is serious offense. I don't care, the argument that it's a misdemeanor, it's a lower level felony. That doesn't pass my mustard. If you're convicted of a crime, that's serious. And it's going to affect a person's life going forward. I'm sure that we've been involved with people that have a rap sheet that goes a mile long. They probably don't care if they pick up an extra misdemeanor or felony, but in this particular case, this is extremely serious for Mr. Gosman. He has no criminal convictions at all. Now he does. He's got it deferred for very, very serious, and the other 2 are very serious as well. I would like I think that how they met is a little bit different than what the state is. My client was a volunteer, did do the bus driving for the school district, but he never drove her on a bus. He never drove her route. My client has a son, and I think he met her through the interaction because I think she helped his son as a young kid walking his son to the bus. And that's how they, I think, made their contact with each other. But eventually they did have contact, but he never did drive her bus route or drive her on a bus. But in any event, my client, I just want to start off, he made just a poor decision. And it's difficult to make this argument because usually I have some reason or justification, but in this case, he just made the wrong decision and there's no way to argue around it. And that's why we're here today. My client, he has a 6-year-old son. I think what's been difficult for him is that he is a widower. His wife is, or his ex, I should say, she is dead. So he is raising the child. And I think what happened here is he was getting attention from someone, a very intelligent woman. She was a minor, of course, but and he had interactions with her. She was positive. She was friendly. My client never entered into anything thinking as this is a relationship, but it did morph into that. And unfortunately, it morphed into something where he's now here pleading guilty to 3 convictions. I also want to say that my client has never met her parents or never had any interaction with the parents, the Nelsons, because I've gone through this over and over, and he never has spoken with them or met with them. But he does apologize for the situation or for what is now, what I heard today is wreaked havoc in their family, and that's not good, especially for someone who is so bright. And I don't like hearing that it affects someone's marriages. This is all around not a good situation. For that, I apologize, and my client apologizes. Whether the Nelsons will accept that apology, I would like them to know that my client is not trying to groom children or go after children. And he wishes this never would happen. And I hope that they can, in the future, at least believe that. They don't have to accept the apology, but at least they would believe that I would appreciate that too. And I feel sorry for the whole entire family. So I would like my court to know that the character of my client, he does not have a criminal record. And Your Honor, we did get him, he did do the sex psych evaluation, and we got on that immediately. And again, I know that Attorney Schmidt was not the district attorney at the time. I will re-provide that evaluation. I don't know if Mr. Renicky looked at it, read it or not, but we will make sure that that is to the DA's office immediately again. So he did take responsibility for that. And make sure that, and when I read it, Judge, there's nothing nefarious or anything that leads me to believe that he's going to have a high level of recidivism. I would like to make some points on this that the state made. These convictions are going to affect him, and so it should. Since he committed these crimes, he will never ever be in law enforcement, and I am pretty certain that he will never have any job with children again. It just will never happen. I mean, it's not just through the courts, but they've got administrative actions through the state of Wisconsin and other states too. So he's completely made it sure that he's not going to have that career path again. He is going to have to raise his son, but it's going to have to be something other than what he did in the past. But I'm sure he'll do that. So he is laser focused. He's not someone that uses drugs or alcohol. I'm not saying he doesn't drink, but he doesn't abuse alcohol. He does not use drugs or narcotics. And his main focus is to work and to provide for his son. He is, like I said, he is the widower, and he wants to make sure his son has what he needs or the best he can have. I would like the court to know behind me, as in most hearings, my client's father has always been here. I know him. Actually, I knew him before I knew Noah. That's how I got the introduction, and he's had support here the entire time. I just want the court to know, I think that his character at the time was abysmal. It was bad. It was just, I mean, again, wait 3 months, or it was 3 or 4 months if you want to have this relationship. Just bad judgment. And I don't have a time machine. I can't put him in it and have him rethink what he did. And now he's sitting here for that. But the need to protect the public, Your Honor, I don't think there's going to be a need to protect the public. He's going to be on the same bond conditions. He's going to follow those conditions, and anything that's required through the deferred agreement and through probation, he will do, and he will not balk at anything. Again, he has no record. So I join in with the argument of the state on a lot of the points, well, on all the points. Like I said, I can't come here and say, well, it happened, but it happened and there's no way around it. It was wrong. He shouldn't have done it. And I just want the court to consider all the other things about him and the good things that he's done in his life up to this point. Thank you very much, Your Honor.
Thank you. Mr. Gosman, I'm going to turn to you now, and this is your opportunity to tell me anything you want me to know about this matter, about you, if you want to clear up any information that you believe was not stated correctly by either of the attorneys. So this is your time to tell me anything you want me to know before I sentence. You don't have to give a statement. It's just your opportunity.
Okay. I would like to remain brief. However, I do think that,
And I'm just going to ask you to speak slowly if you can.
okay, will do. I believe my attorney spoke well for me, and I share those points. I do want to apologize. I want to apologize to anybody that this has affected. I want to apologize to the victim. I want to apologize to the family, and to the community. This is nothing I ever intended on doing. I didn't intend on doing anything wrong. I do agree that it was poor judgment at that time. I have definitely learned my lesson, as they say. That's what I'd like to say.
All right, thank you. Mr. Gossman, so you can understand, because this is your first criminal conviction, and I know you may have been in law enforcement before, but on the other side, and now you're sitting in the hot seat. So I'm going to go over what a judge has to look at, what I'm told I need to look at for sentencing. First, I have to look at how serious is this matter? Okay, then second, I have to look at the defendant, your character, your past criminal record, your employment, all of those things about you. And then I have to look at needing to protect the public. Not only is it needing to protect the public as a whole, but it's needing to protect the public, meaning the victim and the victim's family. So that's what the court looks at with sentencing. And so you can also understand that the court needs to look at probation first. I'm told from my higher courts, I must look at probation first, unless confinement is necessary to protect the public from further criminal activity from you, unless you need correctional treatment. You can't get the treatment outside in the public, or you've not engaged in it or sought it out, and you can only receive it then in an institution, or if probation would unduly depreciate the seriousness of the offense. Okay, so first I look at probation, unless it would unduly depreciate the seriousness of the offense. First and foremost, I want to update Mr. Davis. This psychosexual evaluation is in the electronic file. It was filed July 11th, 2025. I've reviewed it.
It was asked that that's under seal that we.
I believe it is.
Okay, oh, thank you.
But I have reviewed that document. I'm hopeful that Mr. Schmidt and he has as well. So everybody's reviewed that document.
Thank you.
And Nothing jumped out at the evaluator. Nothing jumps out to the court from reviewing that. It sounds like you had a traumatic experience or time in your life with your ex-significant other who has passed away, and that really affected you. That didn't cause this to happen. It didn't cause you to seek out the 17-year-old girl, but it could be a factor. This is, at first blush, when you're looking at this case, without knowing exactly all of the facts as they've been stated on the record, and especially by the district attorney, it looks and it appears to be very serious. An adult who is 32 years old, who's engaging in sexual intercourse with a juvenile, even who has attained the age of 16, is serious. There are underlying facts here that the district attorney has been able to retrieve, as well as your defense attorney, in that this young lady consented and she spoke to you about a relationship and having it develop and go from there. She was 16 or 17 when this all occurred. And the sexual intercourse didn't occur until she was 17 years and 11 months old. 1 month. 1 month away from criminal convictions and criminal charges. However, that's on your side. When I hear the information as it relates to the victim coming through the stepfather, she was a young lady. She may have appeared to be more mature in the things that she said and how she poised herself and what she did, but she still had a teenage brain. She still had the maturity level of a high schooler because she was. And in looking at this situation, there's a significant power imbalance. You're 32 years old, started talking to her when she was 16, and then she was 17. You were an authority figure to her, somebody who could have potentially been a mentor, twice her age. You're twice her age. Now, 5-10 years down the road, twice your age may not be so bad. But here, NJ has not reached a maturity level to be able to thoroughly consent and to consider all of the things involving you, a 32-year-old man, an adult with a child. She has not had the life experiences to be able to do that, to grow. Because if you recall, when you were 17 years old, there is a huge maturity growth from 17, even turning 18 and being done with college, even after your first or of high school, and then even after your first year of college, there's a significant maturity level growth right there. And then an even bigger growth from your second year of college, third year of college, or even if she did not go to college, even just growing and being that age and experiencing life. She was not there. You knew that, and you knew that she had 1 month until she was 18. And that's the difficult part with this case, because I hear the impact that this has had on NJ. Granted, she was almost 18, but she was not yet in that position to be able to make a reasonable and rational decision to engage in a relationship with you. And now it appears to have significantly impacted her well-being, her future, her drive, and her life. You don't have a criminal history. You were at one time a police officer. You're no longer going to get to be able to do that job anymore. And you will no longer be able to work or volunteer around juveniles. And that means all juveniles, not just 16 or 17-year-old juveniles. That's significant, and that's a significant punishment right there. Usually the court looks at deterrence, a deterrence factor in a case, especially a case like this. But again, she was almost to that golden age of 18, where she could have made her own legal decisions, but she's not. So I don't believe that there should be a sentence, or there needs to be a sentence to deter you from continuing to do actions like this, or to deter the community as a whole from committing crimes like this. When I look over the deferred judgment of conviction, it seems reasonable. You're pleading guilty to a felony. If you don't follow the law to the letter, that means that this agreement can be revoked. That means one probation violation, one misstep, one mishap, one something, and this will be revoked. And then you will be in front of the court for sentencing for that felony. And at that time, you will no longer be able to use or possess a firearm for life or vote in any election until your rights are restored. So you can have no contact with anyone under the age of 18. This will run for 60 months or 5 years, and you must pay a $150 fee to the district attorney's office. You must do that within 60 days. I'm going to tell you that's the number one reason I see these being revoked. People don't pay that $150. Okay, so it's very important that you do that. I do find that the deferred judgment of conviction as it relates to the felony count is appropriate. That's a huge hammer over your head, and it'll fall, and only you have the ability to determine if it will. When we're looking at the misdemeanor convictions, in this case, probation would be necessary to ensure that you abide by the law, you follow the law. Somebody's monitoring to make sure that the deferred judgment of conviction is being followed. What is the length of probation that's being asked for?
2 years.
That's what I thought. I just wanted to make sure. All right, so 2 years of probation so that an agent can ensure that you're following the letter of the law. You're doing what you need to do. So 2 years probation for both of those counts. I was contemplating whether or not there should be initial jail time. There should be conditional jail for these convictions. But hearing the facts coming from the district attorney's office that the former district attorney overcharged, there should have only been 3 charges. And these are the 3 charges that should have been initially charged in the criminal complaint. And the other facts about the victim, her age, her consent, her discussion with the officers in the interview. I'm not seeing that conditional jail would necessarily be appropriate. You did a stupid thing that has the potential to follow you for the rest of your life, that will follow you for the rest of your life, and a stupid thing that has now decided that you will no longer be able to serve as an officer. The law can't fix stupid. And any conviction that I give you right now, if I give you jail time, all it's going to do is be a punishment for doing that. So what I'm going to do with regards to these 2 convictions and charges, I'm not going to do a withheld sentence. I'm sure your attorney went over with you what that is, a withheld versus an imposed and stayed. I'm going to let you know exactly what you're going to be facing if you violate. So it's very important you follow the letter of the law. With regards to count 5, the court is going to sentence you to 6 months in jail And as to count 10, 6 months in jail, consecutive to each other. So you have to serve one, then the other, imposed in state. That's going to be hanging over your head. So you know that punishment, and the punishment will be hard and strong. That would be a total of 1 year in jail. On probation, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no contact with any minor under the age of 18, no work with any ability to have contact with a juvenile, and that includes volunteering, random testing of blood, breath, or urine or hair follicle to determine if you're using any substances or alcohol, gainful employment, no bars, taverns, liquor stores, or casinos, or any establishment that has the primary purpose for the sale or the service of alcohol. No contact with the victim or victim's family. Mr. Schmidt, am I missing a condition?
No, those are the ones I would have wanted.
All right, any condition that you would see, Mr. Davis?
I don't know if you can do anything on this, but he has he's raising a 6-year-old boy, and he can have contact with this child, and then Your Honor, for like I don't know if they still do it, like concerts or school, is he able to go and watch his child function with other like sports or stuff like that? They have like a thing for that. I guess I didn't really, I didn't even think of that until you brought it up.
All right, and so he may have contact with his children and any family children, if you're going to a Christmas, those things, because I'm sure your family's there, all of those things. So it doesn't prohibit you from having contact with your family, okay? I'll say, so you can have contact with any family member, even if it's a juvenile. And with regards to the school events, you can attend your children's school events, but again, no unsupervised contact with a minor. So you can go to the basketball games, you can go to the concerts, but you can't have any unsupervised contact with anyone under the age of 18.
Maybe part of that, he notify the probation agent if there's a function he's going to, then everyone knows what's going on.
Yes, I like that. Notify your probation agent. And also, you're going to have to notify the school. I think this is one of those charges. You have to notify the school of this charge. And it depends on which school it is. You would need to notify them that you would be attending those types of things. Because I did have a similar incident with an individual who got charged with failing to notify the school. Okay? So it's very important that you do those things.
I have nothing further than, Your Honor.
Thank you. $443 in fines and fees for both of the misdemeanors. And you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. You're going to need to go to the sheriff's department and provide that. I do not believe that this is one of the convictions that it can be expunged with, but that's up to the Department of Justice. So if you wish to ask to have your DNA expunged from the CODIS system, you would need to write a letter to the Department of Justice, not this court, not to me, to the Department of Justice. You can Google it. It's pretty easy to do. I think that covers everything, Mr. Schmidt.
Nothing further from me.
Mr. Davis.
He had no jail credit, so it covers everything.
All right, thank you.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.